waiting. I don't know whether anyone saw, but the clouds dropped down and we've got quite a view on that side. But I'd like to welcome everybody to SFU VentureLabs. I'm Leslie Esford, I'm the Executive Director. And I'd also like to welcome those on Zoom. If I I've already moved away from the square. Roger, don't do that. I'd like to acknowledge the remote participants as well. We have, this event is actually simultaneously hosted by our partners, VIATEC and Hubspace at the same time. And then we have a number of event sponsors and partners that we have, which are, next slide. Next one. You can see, like, this is not possible without the various law firms, 3 of which you'll hear from today, that have agreed to participate in both this part to give us great valuable insight, as well as for the one-to-one office hours, which we are really grateful for. We have a number of government partners that have all been around supporting IP, which is NRC IRAP, the Canadian IP Office, and of course the Trade Commissioner Service. For our community, this is really about part of, yeah. Can you hear me now? No?
Yeah, we can hear you.
You're online.
Oh, that's the important part.
Just talk loudly.
Okay, can you hear me now? Okay.
Yes.
Okay. They're going to deal with the mic. I'll just use my UBC lecturer voice that I can get, especially Bruce, if you're bad back there, I can get you. Okay. I just like to do, obviously the community, Accelerate IP, VIATEC in Victoria, and Hubspace in Prince George. We're really excited to do this event simultaneously across the province. And as I said, this is an event we really enjoy doing. There are 3 parts to our event today. The first part is we will talk about how to protect your IP when licensing your product, with examples from our lawyers from Fasken, Gowling, and Owen Wiggs. The second part is your one-to-one office hours, and there is a sheet that is around in multiple locations that will direct you to where you are supposed to go for your office hours, if you have office hours. For many of you too, we have an opportunity to do a one-on-one workshop in our training room as well. So if you have any difficulty finding those rooms, let us know. And then the third part of our time together is to actually have a reception, because of course this is the season. And also it allows you to ask questions and again, meet a few people in the community that you don't know. So it's actually a really good, we love these things. So just because we're running a little bit behind too, I want to make sure that we have given our speakers enough time. So first I'd like to introduce Roger Kuipers. He's a partner at Fasken, and he's practicing in the life sciences and IP among others, and he's going to give us an overview and as well give us examples for life sciences.
Good afternoon. So I'm just going to provide as quick as I can overview the main provisions of a license agreement, and then we have a couple of more lawyers that are going to step in and address particular issues that are relevant to IP and licensing. And we're just waiting for the presentation. I can start with my disclaimer. I'm going to say a lot of things. Most of it's going to be right. Some of it might not be. Get what you pay for. I'm a volunteer. Actually, I am paying. And I've got 2 lawyers coming after me to clean up. So if I screw it up, then, you know, thanks in advance. So what I'm going to do is I'm just going to start, and then the presentation can catch up. So the first thing I'm going to mention, and yes. Is there a way to use the microphone? There. We'll switch.
I'll check the switch to make sure.
Testing.
Yeah, you're good. Perfect. All right. Well, like Mr. Rogers with my cardigan here. Hi, kids. All right. Is that good? All right. I am to please. Thank you. I was gonna say, one of the first things that I wanted to mention, which most of you may know, but I thought I'd mention anyways, is that really you have two ways of dealing with IP. You can assign it and you can license it. We're focusing on licensing. The key difference is that if you sign intellectual property, it means you're handing over the ownership of it. It's the difference between selling a car and renting a car. The reason why it's significant within the context of intellectual property is that unlike a car, there's only one and only one person can drive it at once. But as you can appreciate, intellectual property, most of it is like infinitely divisible. It could be used for so many things by so many people. Ask anyone who had Napster back in the day. So let's go a few slides. And then next. Okay, great. So we'll start with licensing. Think of it as a relay race like our technology community in Vancouver here. Often, and this is just an example, but you'll start with a university like SFU. And they'll run the first few laps of this relay race. They'll develop technology and they'll hand the baton off by licensing it to, let's say, a biotech company. And then what happens is the biotech company, and this is, maybe it's another company, but this is what we do here mostly in Vancouver and in DC, is run a few laps, develop that technology, de-risk it, try to bring it to market. And then at some point, because the big markets aren't here and because the huge capital markets aren't here so much, you then have the biotech company sub-license through to, in the case of a biotechnology, a pharmaceutical company. But in the meantime, there may be some other licensing. Like, let's say there's another biotech company with a technology that improves the efficacy and reduces the toxicity of the compound that you're working on. So you could do a cross-license for particular things or license here. You may have another university that's going to provide some research services. Maybe you're going to license the technology to them so that they can do that research. Next slide. So we're going to talk about, well, first of all, a license isn't just in a license agreement. Many different agreements have license provisions in them. So obviously license agreements, but research services agreement, collaboration and joint development agreements, manufacturing agreements, distribution agreements, sales agreements, end user license agreements, all have licensing provisions in them. And so we're going to go over the main provisions: subject matter, scope of use, term, exclusivity, sub-licensing, territory fees, modifications, and improvements. Gone. Okay. So subject matter, this is really important. Identify, what does the license cover? What are you granting rights to? So it's usually patent rights associated with know-how. Those are often together. It can be copyrights, which is often the case if you have a software license agreement, which is primarily protected by copyright, and trademarks. And then sometimes you include materials. So you'll have material transfer provisions in a license agreement. And sometimes it's a separate agreement, but that's something to bear in mind. Next slide. So scope of use. Scope of use defines what the licensee can do with the technology. A lot of technologies have a lot of potential different uses. And so what you do is if you just say you can do everything with it, well, that's not necessarily driving the most revenue from your technology, right? It may be that you want to find someone, if you have a compound, and maybe you have someone who could use it in cancer and someone who could use it in pain or in MS. And what you do is you kind of have a field of use in each license agreement for, and one would be for cancer and one would be for pain and one would be for MS. And now what you've done is rather than just have one license to maybe a cancer company that can't do anything in pain or MS, you're maximizing the revenue from the technology by dividing up those rights, by defining narrowly the scope of use. Next one. Term is the length that the license is in effect. Typically with patents, it's the life of the patent. If you include know-how with that, then you want the know-how license to continue. Imagine that you've got a technology and it's successful and it's in the marketplace, the patent expires, but you don't care. So the patent expires and then the license term ends. And that's okay because you don't need a license because it's off patent now, but you're also using know-how that was licensed in that agreement. So you don't want to do that. So there are strategic considerations, setting aside the patent scenario. If you're a licensor and you don't know if you trust the company that you're licensing to, maybe you have a short term that's renewable, so that if they're really not doing anything, you can, once the short term runs out, you can terminate and find another partner. If you are taking in a license, you want the longest term possible. Imagine that you take a license to a particular technology and you spend 3 years working hard and spending a ton of money, de-risking it technically, finding out that there's, entering the marketplace, getting commercial traction, license runs out, licensor says, that's great. Thanks for showing what a success this technology is, and then license it to someone else. Next. Exclusivity is the sole right to use the technology licensed. That is, of course, if you're receiving a license, it's important and it's good because it means you won't have competition, other people using that technology. But if you're the licensor, you're putting all those eggs, if it's an exclusive license, in the licensee's basket. And if the licensee fails and doesn't perform, then there's an opportunity cost. Next. So what do we do about that? We include anti-shelving provisions, performance milestones, things in the license. If you're going to have an exclusive license, it's going to say, okay, we'll grant this to you exclusively, but by next year you need to raise $1 million, and by 2 years you need to have regulatory approval, and by the 3rd anniversary license agreement you need to be in the marketplace, or else we're either going to terminate the license, or you can compromise. You can say, we'll just make it non-exclusive. So what we can do is we can go to other parties and license that technology, and maybe they're going to make more progress with it. Next. Sub-licensing is the ability to pass the license on to other parties. So in the example I showed earlier, if you are the biotech company who took the license from SFU and you got to the point where Pfizer wants to run with it, then you can sub-license it through to Pfizer, and then they pay you and you pay SFU, and that's your sub-license. Territory. Territory is the geographic scope within which the license rights can be exercised. And where this is important, of course, a licensee is always going to say, I want worldwide rights. But what you have to think about, and again, I'm going to be hitting this biotech hobby horse because that's the last one I gave this presentation to. So there you go. It's whoever you're licensing to, what's their geographic footprint? So in life sciences, biotech, you often do a deal in Japan. And maybe you do that deal first, and maybe it's a good housekeeping seal of approval. And then you go, and then for Europe and North America, maybe you go to Pfizer. And Pfizer isn't in Japan as much, so you do a deal with Takeda, and you go to Pfizer and you say, hey, Pfizer, Takeda, you know, they signed a license agreement. You should look at this. And that way, by slicing and dicing the rights geographically, you're also not just, well, you're maximizing the potential revenue from it. Next. Granting provisions. So all of the provisions, and this is where you have to be super, super, super careful, because I'm going to show an example of a terrible, terrible provision that put a company out of business. That's a teaser to keep you awake. But so here it is. This is all in one sentence, and it's usually in section 2.1 or section 3.1 of a license. And so what does it say? Licensor hereby grants the licensee a perpetual, there's your term, right? Goes on forever. Exclusive, there's exclusivity. Sub-licensable, worldwide, and that's your geographic scope right there. Right and license to use, and in this case, again, a biotech, the XDX compound on, and wait for it, here comes the field of use, drug-eluting coronary artery stents. So what happens in this, broad geographically, exclusive, but you're not giving rights to injectables, and you're not giving rights to oral tablets or whatever. So if the drug of the, well, I mean, you wouldn't really want to have, if the XBX compound had efficacy applied, just, you know, other than in a stent, then you'd still be able to enter into a deal with a company that would distribute it like that. Next. Fees. So this is the creative part. This is the part where the licensor gets paid. And so we have a number of options. We've got fixed fees, milestone payments, and royalties. And then also you can get shares in the licensee. And typically a university will take many of these, but sometimes all of them. That's the standard for universities. But in commercial agreements, not so much. It varies a bit more. Just checking the time. Okay. So what do you need to think about with cash? You need to think about things, or sorry, compensation. You need to think about cash flow. Your startup company can't pay a lot up front. You may not have a lot of money. Okay, so you got to think about that. You also have to think about, well, if I'm deferring being paid, there should be more upside. So in that particular instance, you may back end the compensation and you may have a higher royalty in return for a lower upfront payment. And so those are kind of the things that you think about when you put together a compensation package. Next. So fixed fees can be upfront payments, they can be yearly installments, they can be monthly installments. If you're doing a deal with a company and you don't know how serious they are, you don't know if they're adequately resourced financially. What you could do is you can negotiate a big upfront payment. And that'll kind of smoke them out. If they don't have the money, there's no deal, nothing gets signed. And if they do, then at least you've got something up front as well, and to mitigate against the risk that they don't succeed. Next. Milestone payments are payments that are typically, well, tied to milestones. And so within the context of a biotech company, well, actually all companies, one of the milestones would be obtaining financing. So, and part of the rationale behind that is that, you know, if it's a university, they're saying to the company, look, we know you guys don't have a lot of money right now, but when you do a $5 million raise, we want $100,000, because that's some of what we may have asked up front, but you didn't have the money then. Entering different phases of clinical trials, that's a very common milestone for which there's payment. Obtaining regulatory approval and first commercial sale of a product. Next. Royalties. So royalties are tied to sales of products, and they allow the licensor to participate in the upside. And so that if you did just a cash deal up front and you thought that the technology was maybe going to work, and you took $100,000 and the licensee hits it out of the park and makes hundreds of millions of dollars. Like if you don't have a royalty, you don't participate in that. So that's what the royalty is about. Now the royalty can be tied to unit sales. The name George Scott is. No, actually, someone's in my front door. So royalties can be based on unit sales, or they can be based on sales. They can be on gross and net. And usually the common approach is to base them on the dollar value of sales, funds received, but net. But the net isn't like Hollywood net, where Star Wars never made any money. It's like just a few things like rebates and transportation charges. And in industry, there's kind of a acceptable bunch of things that you can deduct from gross to get to the net that you pay the royalty on. They're riskier than fixed payments, but you do get part of the upside. Now, the key thing to make royalties work is to make sure that the licensee isn't cheating, or if you're the licensee, kind of make it fuzzy so you can't cheat. But I'm a lawyer. So you need a clear calculation method, right? And then on top of that, you need the licensee to keep records, and you need an audit right. You or your accounting company needs to be able to go in there and make sure that they're being honest in calculating royalties. Shares of the licensee. That's self-explanatory. Shares go up and down. So again, that's something that fluctuates. And maybe there's a bit of a premium that you get from the success of the technology, but there are a few risks. So with a private company, it's really hard to value what the technology is. So it's usually just a negotiation around what percentage of the shares of the company. And also there are liquidity risks. Private companies, you can't just sell the shares. There's no market for them. So there's that. If you take shares in a public company, one of the main concerns is share price fluctuations, because, shares go up and down, and you did a great deal. You negotiated, by the time you signed, the shares are worth less, and that's never good, or more, and that is good. And then there are escrow considerations. It may be that the stock exchange or the securities commission that governs the issuer's shares says that, well, you have a 4-month hold or a 6-month hold or something like that. And so that you're sitting on the shares, but you can't sell them. Next. So modifications and improvements. So question number 1, you license technology to someone. Do they get to tinker with it? Do they get to try to improve it? If you're a university, almost always you say yes, because the technology needs to be worked on to go to market. If it's an end user, if you've created an app, you don't want your end users to be busting into the code and changing stuff, and so then you would say no. But if you do allow modification, then you need to start thinking about, well, who owns the improvements? Who has rights to the improvements? And so typically, a university licensor wants to own all those improvements, but they will include the license. They'll include those rights in the license. So you'll get to use them. It'll be exclusive rights. The university will have non-commercial academic rights. But the point from the university's perspective, or even another licensor's perspective, is that if things don't work out, they'd like to have the basket of technology, their original technology, and those improvements, so that when they turn around and they find another partner, they've got they've got the benefit of some of the effort that went into improving the technology. Here's one tip. So, and this is a little complicated to set up. I've seen it done before, and it's actually quite good. So let's go back to the scenario where you have a geographically discrete exclusive licenses. And you know that if someone in Japan comes up with an improvement and shares that with the company in the US, that's not a problem. But the US company is better off. Japanese company's not losing any sales because there's no, because the companies, so the markets are distinct. Next is the fancy part. Here it is. So let's say you have an Asia partner, North America partner, and Europe partner. And what you can do is you can have them enter into improvement provisions and agree to share. And so if Europe agrees to share their improvements with North America and Asia, then they get the improvements from those other markets. And so it's kind of a way to globally advance the technology and accelerate commercialization. Tough to do though. So this is the teaser, the Rumpelstiltskin clause I told you about. The thing to worry about in licensing, I showed you that granting provision, right? It was one sentence and it covered 6 or 7 really important things. And if you don't pay attention, you can get in trouble. And so this is a real provision from an ag biotech company, not in British Columbia, and I didn't draft this because then I wouldn't be throwing about it. And so this is your standard somewhat, and it was a small biotech company, ag biotech company, doing a deal with a big US ag biotech company. And so it goes something like this, right? So hereby grants the big biotech company exclusive worldwide license to use the grant sublicense to use any and all intellectual property owned by small biotech, oh, that's a lot, related to the field of use, whether currently existing or later developed. So there's your improvements language, right? So at a certain point, after having signed this, got to get the deal done in a big rush, can't afford a lawyer. Like a year later, they're looking at this and they realize there's no point anymore for that company to do anything, right? Hey, I'm going to raise funds to do some development for technology that this big company's going to own, right? So it illustrates how little pieces of language within a sentence can actually, pose an existential threat to the company. Or just selling the fear. All right, that's it.
I was actually remiss to point out that Fasken graciously agreed to host our reception afterwards with Innovate BC and Accelerate IP. Big key point was that we couldn't order alcohol without Fasken, so thank you for coming in. But I will say that we asked Roger to speak before we asked him for a sponsorship. So we did ask him first. That was the way it went.
They had no leverage, but we're paying it.
Next, I would like, and Ronnie's gonna say, no, I'm not coming again, so now that I hear what they do. So next, I'd like to introduce Ronnie Jones, a senior associate at Owen Weeks, focused on the IP in the industrial, mechanical, and computer-related fields.
All right, can everybody hear me with the mic?
Yeah.
Fantastic. So today I've been asked to talk about specific issues that come up when licensing technologies that incorporate or involve artificial intelligence and machine learning. I'll start with the same disclaimer that Roger had, and I'll leave it to Rob to clean up any mistakes that Roger and I made. And, my goal today is not to tell you what you should and shouldn't do, but to help you identify issues that you might want to consider when entering into license agreements that include AI and machine learning technologies. I'm going to use the terms AI and machine learning interchangeably. I know that's not technically correct. I hope you'll forgive me for that. Sorry, presentations. So When first thinking about a license agreement with AI and machine learning, you want to think about what specific aspects of the technology are being licensed. There are lots of different aspects that can be involved in machine learning and AI technologies. We might have actual improvements to AI and machine learning themselves. It could be a new machine learning algorithm or improvement to machine learning. Or we could be talking about the use of machine learning or AI in a specific context using certain modifications. We could be talking about a license for training data. Often it's very tough for startups to get adequate training data to train their models. They might team up with a company who's been in the industry for 20 or 30 years and has historical data that can be of huge value. So it might be licensed training data. It could be, we could be talking about methods of preparing, obtaining, or cleaning up training data. It could be the method of training itself. It could be an untrained model that's valuable or a trained model. It could be hardware that incorporates AI or machine learning. It could be the output of machine learning. So we often see AI models that create photos and videos, but also people are creating, I think I'm out to the mic. All right, can you hear me again? Very good. So it could be the output of AI or machine learning that you want to license. So perhaps somebody has developed software using AI or developed some sporting goods where the finite element analysis is effectively done by AI. So there could be all sorts of different things that you want to license. Sometimes we want to license a combination of these things. Sometimes it's only one of these things. It's really important to define that right from the start. If you're the licensor, you don't want to license more than you need to. If you're licensing a trained AI model, you might not also want to provide your training data. Instead, you might want to keep that confidential. Or if you're a licensee, you want to ensure that you license enough of these aspects to actually meet your goals in using the technology. So as Roger identified, there are a number of different IP rights that you might license as part of this. There might be patent rights, confidential information, know-how, trade secrets. There may be copyright, there may be trademarks. It's important to identify which of these relate to the technology you're looking to license and how they relate to each other. So it may be that you're licensing a patented technology, but you might want the know-how that goes with that to do a good job implementing it. So that shouldn't be forgotten as well. While trademarks might not be entirely obvious when you're licensing a technology, it might be important. Perhaps you're using ChatGPT technology, and it's important to you in your marketing materials that you can refer to ChatGPT and say, well, our technology is powered by ChatGPT. So you may need a license to use their trademark. Ownership is a big issue in AI. It can come up in various ways. One question that I often get asked is, can anyone own the output of AI, or who owns the output of AI? AI is creating a photo or a video or software or anything. Can that be owned? It's a great question, a question that is unclear in its answer, unfortunately. Some countries have said that there can be no ownership in inventions created by AI, that inventors must be human. Other countries haven't made decisions. My expectation is the legislation will slowly catch up with the technology and then probably fall behind again. And so one of the things you might consider is preparing your agreements to allow for the law to go either way. So preparing it for perhaps there can be ownership in AI created inventions and materials, or perhaps there can't, and maybe your agreement should allow for both opportunities. If there can be ownership in the output of AI, who should own it? Should it be the licensor because they created the AI, or should it be the licensee who's using it and putting the inputs in it? Or there could even be the end users. So perhaps you have a first company licensing their technology to a second company, who then allows end users to use it, put in the input. Should those end users have rights in that output of the AI? Ownership aside, another question is who should have the right to use that output? That output could be not only valuable to the end user, but it could be valuable to the licensor or the licensee to use for retraining or updating their model. You might want to include license provisions that say, sure, we license down to you to use the AI. Once you're using it, we also want to license the inputs and outputs so that we can use that to retrain our AI and continue to improve upon it. If you're a licensor, that's a great clause. If you're a licensee, that might be a problem. Perhaps you've got confidential information in the input or the output that you don't want to share. Perhaps there are privacy issues. Perhaps you don't want that information to go back up to the licensor and then be handed back down to one of your competitors. And so those clauses should be considered carefully. Training data. So ownership comes up in training data as well. Commonly, we are seeing, well, in the news, that some training data comes from scraping the internet. So imagine I'm a photographer, take a beautiful photograph, I put it up on my website for advertising. Somebody wants to train their generative AI to create photographs. They scrape all these photographs, including mine, off my website, and they use that to train their AI. Are they infringing my copyright? Well, that's a question that's in the courts right now in a number of countries, and we will see the answer to that. But if you're licensing that training data, should you be worried that perhaps it infringes somebody's copyright? Or if you're creating that training data and licensing it to somebody else, should you be worried that there's a risk baked right in? And then improvements to the technology. As Roger pointed out, there can be cases where your licensee is making improvements to the technology. Who should own that? Who should own it when the licensor makes the improvement? Who should own it when the licensee makes the improvement? Who should own it when the improvement's made jointly between both of them? What about if the end user is involved? Those can all be dealt with in the license so that it doesn't become a problem later on. Some of these issues can be dealt with by allocating risk, and allocating risk in a contract is often done in sections called warranties and representations. So if you are a licensee, you might want to see something that says that the licensor promises that the training data lacks bias, is accurate, is properly licensed from third parties, properly cleansed of personal information that can have privacy issues. These are all great things if you're the licensee. If you're the licensor, very tough to promise any of those things. You might have terabytes upon terabytes of data. How can you go through all of those to make sure that all of these things are true? And so both parties should be very careful. Are those promises there? And if they're there, can we actually make sure they're correct? Yeah, so another question is, does use of this AI or machine learning comply with local regulations? Whose job is it to make sure that that is true? If it isn't true, who's liable for any fines or fees or issues that could come up from that? And then performance. If you're going to license AI technology from somebody, you probably want it to meet certain performance standards. How do you do that? You can have metrics built into the contract. You can have testing periods, trial periods, validation. There are various ways to do that. And finally, when AI or machine learning is incorporated into a product or a device, and maybe is controlling that device, you might want to have liability if there are potential injuries from it. If the AI doesn't do what is expected and somebody gets injured from the device being controlled by it, who's liable for that injury? AI can be especially valuable because it can be constantly updated, constantly being retrained, constantly being improved. That comes with its own complications. When you're licensing that technology, are you licensing the technology as it is on the day when you sign the agreement, or are you licensing it including those evolutions over time, those improvements? If you're a licensee, you probably want it to include all of those evolutions. If you're the licensor, you might want to limit it. What if you get to a point where it's really, really good and you want more money for it? Well, if you've already licensed all the improvements, that might be a problem. As it's being updated, whose job is it to update it, to retrain it? Sometimes that occurs automatically, and that's relatively straightforward. Other times it needs to be done either by the licensor or the licensee. How often is that done? Who provides the training data to update? Who owns the evolutions? These are all questions that can be dealt with upfront. We hope that as your AI technology is being evolved and it's improving, but what if it's not improving? What if there's deterioration in the results that it's outputting or drift? Who's monitoring for this? Who's liable for that? Whose job is it to fix this? These are all things you might want to include in your license. So there are lots of potential issues that you should consider for AI licensing. What I want you to take away is IP licenses start with a good understanding of the technology. The terms of your agreement really depend on what the technology is and different depending on what you're licensing. They should be forward thinking. It's not just about what you're licensing today, but what's going to come from it in the future, especially with AI technology, which is continuing to evolve as you use it. There are terms specific to AI and machine learning that otherwise might not be required. If there's anything you take from today, it's that IP licenses aren't one size fits all. I often have clients ask for, can you please provide me an IP license template I can use for everything? And the answer is no. You really need to go through it term by term for every specific license situation. And I'd encourage you to do so. Thank you.
And I'd say make sure you talk to a lawyer. And so I'd like to welcome up now Rob Ripley, from a partner from Gallings WLG in Vancouver, who also leads the IP department with expertise across multiple technology sectors.
All right. Yeah. Everybody hear me? Yeah. Okay. I guess one of the benefits of going last is I can say whatever I want and neither correct me. So this presentation is about the IP rights in an AI-based product itself. So Ronnie was just talking about, you've got your AI-based product, maybe it's an integrated piece of hardware, maybe it's a model and you want to license it out. This is about identifying those rights that are in the product that are going to be licensed out. Go to the next slide, please. And the applicable IP rights I want to talk about are copyright. That protects against copying of, in the AI context, code, both in source code and object code. Maybe in training data, it really depends on the data, but I'm really thinking more about the computer code that's used to implement the model. Patents, that protects against copying a function. So copyright does not protect against copying a function. If you have this wonderful AI model like ChatGPT, and you keep all the code a secret, and then someone else like Facebook comes along and says, that's a wonderful model, I want to independently create that myself. They are totally allowed to do that under copyright. If OpenAI wanted to stop them from doing that, they would have to rely on patent protections. Patents protect copying of a function. And trade secrets, they protect against the theft of valuable secret information, such as your source or object code, training data, model weights, anything that provides economic value to your business that you can keep secret and that you are taking reasonable measures to keep secret. Now, these three rights can be used, can be stacked to protect the same product. So for example, you can have a trained machine learning model. There's copyright in that. There's code in the source and the object code. You can patent the functionality in that, and that patent function, that patent protection can live on top of the copyright protection. And you can also keep the code itself a trade secret because you don't have to put the code in the patent that publishes. So in that example, you've got all three rights living together and protecting your product. Conversely, you may not really be using any of them. You may open source your machine learning model, in which case there's either no patent on it or you've granted a very permissive patent license to everybody. You're not keeping it secret at all because you open sourced it, you put it on the internet. And yes, copyright may live in your machine learning model, but when it's open sourced, again, you may have licensed that pursuant to a very permissive license. So practically speaking, you're not enforcing your copyright. So there's lots of variety here. And like I said, they protect different aspects of the same underlying technology. How you use them really depends on what you want your business model to be, and we'll talk about that. Next slide, please. So let's go through the rights. So for copyright, like I said, it's generally applicable regardless of business model. It's always going to be there. You can choose not to enforce it. You can very permissively license it, but it will be there one way or the other. One thing I want to emphasize in AI is that open source is very prevalent. So when you go online and you're trying to find machine learning models to download and to tinker with, almost certainly those are going to be, almost by definition, open sourced models. So you want to know what licenses you're using to build your product. Because if you build your product starting with the quote wrong kind of open source license, then when it comes time to do due diligence, when it comes time to raise money to sell your company, it can be a real big problem. So there are, generally speaking, I'm going to say two kinds of open source licenses we're going to talk about. One are permissive licenses. So if you go online and you Google and you just see what's on the internet, you'll find MIT, BSD, Apache licenses. They're very common. And they generally let you do what you want to do with the code. There are some hoops you have to jump through. You have to provide attribution, you have to provide a copy of the license. But generally speaking, you can download that stuff, you can incorporate it into your product, you can change the code, you can commercialize it, and you can still keep your code confidential if you want. You can still sell it for money. You have a lot of flexibility, and you're usually not going to run into big problems when you're trying to raise money or sell your code. On the other hand, you have relatively restricted licenses, such as, but not limited to, the GPL and its variants. So the GPL is a license where if you take GPL license code, you download it, you put it into your product, then not only that code, but anything you're linking to, the overall program into which you are incorporating that GPL license code, you go and then you distribute that model to other people. You have to make your source code publicly available on request, which you can imagine is a real big problem if your business model is licensing your source code for money. So that's why you have to be aware of the GPL. The LGPL is a variant of that. So the LGPL applies to libraries, the L. You download the library, you're allowed to use the functionality of the library to change it. And if you follow the terms, you have to make any modifications to that library public, but you don't have to make everything else you're linking the library to public. So that's okay if you use it properly, generally speaking. And the AGPL, that's a variant of the GPL where you might have noticed when I said GPL kicks in, it's when you distribute software, when you actually send copies of it to people. That was great 25 years ago, but of course now there are lots of cloud-based deployments where you don't distribute software. And the people who wrote the GPL said, we're not down with that. We need to modify this license. We're going to make the AGPL. So even if you are running a cloud-based operation with AGPL licensed software, you're going to have to make your source code public on request. And, you know, interesting, I find it interesting to Google around, and you can go to Google's, you can Google Google's open source policy to find that, you know, they say you want to use the GPL, that's okay. We're a cloud-based company. We don't distribute software. That's fine. The AGPL, don't even bring it on campus. They're like, you can't use it. You can't use it in private projects. There's just too high a risk. The AGPL will somehow get into, I don't know, Gmail, Google Cloud, what have you, and they don't want any of that. So those are the inbound consequences I was focusing on when you're downloading models and using them. Of course, if you wanted to open source your own software, then these considerations apply in reverse to whatever you want to let people do with your software. Maybe you just want to put it out there, get some name recognition, let people do what they want. You want to use a permissive license. You want to exercise more control, then use a restricted license. Next slide, please. And then we'll go to patent and trade secret. These are two sides of the same coin for how you want to protect something. Patents, of course, in order to get protection, they have to be public. You can go online, you can search for patents, you can find them. Trade secrets, you can't. If you can go online and you can find a trade secret, it's not a trade secret. So they're sort of diametrically opposed ways of protecting something. Really, this decision is going to hinge on a few key considerations. So budget. Trade secrets, once you have your trade secret infrastructure in place, the right legal language, the right practical measures like hardened computer systems, visitor policies, things like that, then you don't have to spend money protecting each additional secret you generate. An employee writes some code, they push it to your protected Git repository. It's confidential, limited access rights, it's secure. Patents, you've got to retain me or Ronnie or some other people I see in the audience who then have to pay to draft an application, to file an application. It takes time, it takes money. So budget's important. Ability to keep secret during commercialization. So if you can commercialize your invention and keep it secret, like in a SaaS deployment, then trade secret protection's an option. It's at least there. Some stuff you can't keep secret when you commercialize it, right? If I'm going to download, or excuse me, not download, I'm going to create a piece of image analysis software, I'm going to publish that, and in order to attract talent, my programmers tell me we want to be able to publish this. Or I've gotten into a sponsored research agreement with the university because I want economical student labor, and the university says we're a university, we want to publish, then you can't keep it a secret. That's not an option. So there, if you want to protect functionality, it's patents or nothing. Ability of competitors to independently develop. Maybe you can keep it a secret, but once the competitors see how much success you're having with your product, they're going to say, that's a great idea. I want to do that too. And if they're going to be able to do that, 6 months, a year and a half, 2 years, you may think to yourself, I can keep it secret, but I'm only going to get a year and a half head start anyway. Maybe that's not good enough for me. Maybe I'm going to go and actually file a patent for that and try to get a longer term of protection, because patent protection is 20 years from the date of filing. A fourth one I didn't put on there, but we'll come back to is just, how technically cool is it? How technically innovative is it? In order to get a patent, you got to convince the patent examiner that what you got is sufficiently different from everything that has been done in the history of humanity to justify being granted a patent. And sometimes you can't do that. So that would be also something you want to use. So what are some hypotheticals here just to illustrate what we're talking about? Maybe you've got low budget, you've got a SaaS platform, you can commercialize in secret. You don't think your competitors are going to be able to reverse engineer what you're doing, or not even reverse engineer once they see what you're doing. You think it's going to take a very long time for them to really replicate your secret sauce, and you don't think they're going to be as good as you. That is something you say to yourself, I can. That, trade secret's a real viable option there. In fact, even if I got a patent for it, how would I know my competitors are doing what I'm doing? I might not be able to find that out. So trade secret, good option. Alternatively, maybe you've got budget, you can't commercialize it in secret, maybe you have to open source it, or you have to publish it like we were saying, or your competitors can create it after seeing success. Then you're thinking, you know what, not much of a legal downside to patenting. I can afford it, I have the budget, I'll take the risk, let's do it. Consider different aspects of your product too. Ronnie was talking about training data. You can't patent data. You may or may not have copyright in your data, but you can keep your training data secret. Whether it's licensed or, if it's licensed, you have to keep it secret. If you own it, you probably want to keep it secret. And you can do that in conjunction with patenting. Next slide, please. And one thing that is important to remember, if you haven't decided, do I want to patent, do I want to keep it a secret, you want to avoid publicly using, publicly disclosing, commercially using, even secret, selling, or offering to sell whatever you may want to patent until you make that decision, because any of those things may make it impossible for you to patent after you do. Next slide, please. What are some other issues to keep in mind when you're trying to protect and commercialize AI-based innovation? So liability from training or generating copyrighted work. So Ronnie touched on this. It's been in the news that ChatGPT very famously is trained on the entire internet, right? Was that legal? Was it not? Hey, we'll find out. So, same thing, generation of copyrighted works. There is lots of litigation also on if a model was trained on a copyrighted work and it outputs something, what's the liability attached to that and who is going to be liable for that? I think there was a case, I think it was a Reuters photo that had a Reuters watermark and somehow that ended up in the actual generated work. Look, that's going to be copyright infringement, all right? It's going to be who's going to be liable for it. They're figuring it out. It's something you have to keep in mind. What are ways to deal with this? Well, traditionally, when you were going to license an AI product for use in your own product, you usually get some kind of guarantee or warranty from the vendor who's licensing it to you. But in AI, actually, that has not been the case. I would still say it's generally not the case. The only exception I know off the top of my head is Microsoft. They've recently, last few months, announced that if you use their Copilot technology, the right way, the way the agreement spells out, they will indemnify you if somehow that Copilot technology results in copyrighted works. Adobe as well, in response to a lot of these image generation types of generative AI, they're saying, you know what, you can come and you can trust our AI because we do generative AI, but we guarantee you it's been trained on clean data sets. So this problem of maybe accidentally generating a photo where you have a Reuters watermark, or maybe the customer, you, the innocent, practically innocent end user, could be liable, they're saying that's not going to be a problem because we guarantee at Adobe, every photo you clean with Photoshop in the last 40 years, I don't know if that's what they're doing, but I wouldn't be surprised. It's been used to train this AI and it's going to be okay. And you also see in some business models, customer-specific deployments to prevent leakage of confidential information. I think a few months ago as well was in the news that some engineers from Samsung had put in a whole bunch of confidential technical information into ChatGPT, which is not good because ChatGPT learns. So you've got a lot of AIs, in the legal space, we see them a lot, get called a lot by people trying to sell, firm-specific deployments trained specifically for an application like law or what have you, where they're not going to take anything you enter and recycle it to other customers. Similarly, if you are in a business where you need to be able to take the data your customers are entering into your training model, and you want to be able to use it to incorporate or to improve your program for the benefit of other customers, that is something you need to put in your terms of service with your customers. Next slide, please. So in terms of a few examples, let's use a non-hypothetical example. Company that went through whatever it was, 18 CEOs in 10 hours a few weeks ago, OpenAI. Something I heard a lot in the press, which I noticed being an IP lawyer, was a lot of commentators saying, OpenAI is great, but if they go under or what have you, there's no, Microsoft says they have a license to the IP, but what's the moat? You see these other companies, you know, Facebook has Falcon for these other LLMs. There's no moat there. And really what they're talking about there is patents. OpenAI doesn't have it. I would push back on the notion that there is no moat. There is a lot of a natural monopoly, I would say, in a business particularly like that. They need a ton of compute, right? There's a reason why you're hearing that the OpenAI competitors are like Facebook models or Amazon models or Apple models, right? You need, literally, it probably need several tons of compute in order to do this processing. You need a ton of training data. And the business environment, when ChatGPT was trained, is a lot different than now. Now people are much more cognizant of the fact that, you know, all the work they put on the internet is being mined for free to generate $40 billion businesses. So if you're going around and training a model now, it'll be harder for you now because people are putting on their scripts in their site, don't train using this site, which even if you ignore it, is going to increase your liability if they ever come after you. So it's a bit of a different environment. It's stuff to keep in mind. And I'll just say that, yes, they don't have any patents. Yes, that's potentially a problem. Doesn't mean they don't have any IP, right? They got a ton of copyright, they have a ton of trade secrets. Microsoft didn't give them $10 billion for nothing. Next slide, please. And then a couple of hypothetical examples. So let's do example code 1. You have an iOS application. There's a lot of development right now leveraging ChatGPT APIs in the background for enhanced functionality. And you know, could be stuff like a chatbot, could be stuff like using ChatGPT for specific kinds of applications, you know, real estate, what have you. They may be new applications, new technology. Could be no downside to patenting from cost, right? Like maybe you can't keep it a secret. You want to put out an iOS app, everyone's going to see it. But if you're just using an API on the back end that's being publicized for this kind of use, is that going to be technically innovative enough for you to justify patenting? And I would say you're getting kind of close to a commoditized product where really you just want to get to market first. You want to get a strong brand. You want to differentiate based on that. Because going hard for a patent for an iOS app, where especially if that time and money and spend is going to slow down development of the app, may not be the best idea. And that's a speech I've given many times to talk much business out of my office. And example code 2, maybe you've got a B2B business. And you're applying AI for image processing, the security space, the medical space, right? Higher price point, you're deeper in the tech stack, you're a little closer to the metal, you're doing much more lower level processing. You're not just using a custom built, or excuse me, you're not just using a generic API, you're developing the APIs. Strong competition with deep pockets, where they are going to be able to invest and compete with you. And if you don't have some kind of competition enabler, they may just be able to outspend a startup. There, I would say that tends heavily towards patenting, right? You need some kind of asymmetric right in order to try to level the playing field. That's my last slide. Do you have any questions? I'm happy to talk. Thank you.
Dave, do we have time for a question or no?
Unfortunately, no, we can do it in the reception.
Okay, so you guys are all gonna hang out for the reception afterwards? Okay, good. I actually realized as I was going to thank you guys that you're actually the 3 R's. Roger, Ronnie, and Rock, thank you so much.
We should start from.
You guys,
Boy band.
our boy band, we're looking forward to the boy band coming out for the reception afterwards. Now, Dave, do you have a different starting point for the one-on-ones?
Couple things for the one-on-ones. I'll just for the one-on-ones, the schedule is posted on the wall. So your company may be scheduled for a one-on-one. I don't have capacity to do that for everyone, but there's also IP fundamentals for a lot of companies, both in person and online. The list, if you're scheduled for that, the list is again on the wall. And everybody who's, this is for the one-on-ones you can see on the screen. Everybody who's online, we will post this in the online Zoom call, and we'll also assign everybody to a breakout room so that you're in the correct place for the session. All right, good, thanks very much.
Okay, and I just want to identify Ryan over there. So Ryan or Dave can actually probably answer your questions. I think Dave's going into a breakout room though, are you?
I can go online.
Okay, so Dave's online. So please stay around for the reception afterwards, and thank you so much for coming today. To VIATEC and Hubspace and all those online. Thanks.